The Cowichan Tribes versus Canada decision should not cause panic for property owners. However, it does require reforms to restore confidence in private property rights while upholding Indigenous rights. On August 7, 2025, following a trial spanning 11 years, the BC Supreme Court sided with Cowichan Tribes, accepting their claim to Indigenous title over the Lands of Tl'uqtinus and to fish the Fraser River's south arm. This court recognized Indigenous title as legally superior to existing property interests derived from the Crown. Property rights in Canada are strong but not absolute. The Crown holds underlying title and grants interest to individuals and organizations. The strongest of these is fee simple, which allows owners to occupy land, exclude others, rent, transfer, sell, bequeath, and use land as collateral. By contrast, courts treat Indigenous land rights, grounded in historical use, occupation, and treaties, as protected under Section 35 of the Constitution Act. In February 2026, Crown Indigenous Relations and Northern Affairs Canada and the Musqueam Indian Band signed the Musqueam Rights Recognition Agreement. This recognized Musqueam Aboriginal title within their traditional territory. However, its geographical limits were not clearly defined, nor its implications for property owners. Scholars such as John Borrows have long warned of an inevitable collision between Indigenous title and private property rights. The Supreme Court of Canada's 2014 decision in Cowichan Nation versus British Columbia held that Indigenous title is a prior and stronger right and displaces the Crown's ownership interest in the land. Its effect was felt by Edmonton entrepreneur Barry Slosky, who purchased Grace Islet in 1990. Authorities later confirmed that the islet contained human remains and designated it an archaeological and heritage site. In 2011, Slosky started to build a house on the land. First Nations objected, but failed to halt the build, until the Tl'uqtin ruling empowered them. Cowichan Tribes Chief William Seymour asserted Aboriginal title to the islet and threatened litigation. Rather than risk a precedent-setting ruling, the province purchased the land in 2015 for more than $5 million and transferred it to the Nature Conservancy. Borrows warned that governments can't buy land every time Indigenous title collides with private property. The approach is too costly, destabilizing for real estate markets, and politically polarizing. In 2024, the Ontario Court of Appeal's decision in Chippewas of Saugeen First Nation versus South Bruce Peninsula applied similar reasoning to the Cowichan decision. The court ruled that a narrow strip of land omitted from reserve boundaries due to a surveyor's error was never lawfully transferred. Despite the existence of an 1854 treaty and later Crown grants, Indigenous title prevailed over later private interests. For Indigenous title and private property to matter, Canada must build a policy framework that allows them to coexist. Accelerating resolution will require sustained federal and provincial funding, expanded treaty negotiation capacity, legislative timelines, and stronger support for Indigenous communities so they can participate as equal negotiating partners. Governments must also commit to streamlined dispute resolution mechanisms and credible compensation or accommodation frameworks that make negotiated settlements workable. Addressing the constitutional imbalance should not weaken Indigenous rights under Section 35, but it should clarify how those rights interact with existing private titles. One solution would be an interpretive amendment to Section 35 stating that recognition of Indigenous title does not automatically invalidate good faith registered property titles. Instead, recognition would trigger a duty of reconciliation and compensation. In practical terms, this would mean compensating Indigenous nations where returning land is impossible, offering alternative lands where feasible, establishing revenue-sharing arrangements on resource-rich lands, and creating clear legislative frameworks to govern these processes rather than leaving them to decades of litigation. The guiding principles must be clear. Recognizing Indigenous title should not automatically extinguish good faith registered property rights, and that governments must reconcile overlapping claims through fair and transparent remedies. Compensation, co-management arrangements, land-for-land transfers, and revenue-sharing mechanisms must be credible, timely, and enforceable. This would move Canada from a collision of rights with unclear consequences to fair coexistence.
Please like, share, and subscribe if you like this content.